and it's time for us to get into the state of the nation, where we put our pulse on certain things in the nation and try and see whether we have a healthy heartbeat. Today, we'd like to look at the criminal justice system in Kenya, and to have that discussion with us this morning. And before I introduce the panel, just a quick reminder that you're welcome to participate in the conversation. We'll be opening up the phone lines at some point, but also you can communicate via social media. The Twitter handles are going to be scrolling as we carry on with the conversation. It'll be good to hear what you have to say. Now, to the panel, and I'll start with the lady, and we have Lady Justice Grace Ngenye, who's a High Court judge at Milimani with the Criminal Division. Welcome, and good to have you.
Thank you very much.
We also have Jacob Ondari, who's the Deputy Director, Public Prosecution. Thank you for joining us, sir. Lenson, Njogu, who's Regional Coordinator, Legal Resource Foundation.
Thank you.
And last but not least, we have Jasper Ombati, who's the Director of Reforms, the National Police Service. Welcome, sir.
Thank you.
All right, so we'd like to discuss the criminal justice system in Kenya. And let me start with you, Lenson Njogu. And this is based on the fact that there was an audit that was done by the National Committee of Criminal Justice Reforms. And they came up with an audit. And maybe let's start with what is it that informed the audit?
Okay, thank you, Gitonga. If you remember some time back, as a country, there was an outcry by members of the public in terms of access to justice, and especially for the poor within the country. And as a Legal Resources Foundation, and together with Rodi Kenya, we were able to conduct an audit on the criminal justice system, which focused on case flow management and conditions of detention. This we did on behalf of the National Council on Administration of Justice, which majorly looks at policy and administrative reform within the whole justice sector. This the audit that we came up with, and they had very interesting facts because we did not really interview directly people, but we relied on official records. So when we got to police stations, we were able to look at the occurrence book, the cell register, the inventory for evidence. We went to court. We also looked at, again, the official documents of the court. At the children's remand homes, the same thing. When you go to prisons, we also looked at for example, remand register, documentation registers, and every other register that was there. So it was not prone to perception, but the facts and the statistics.
So you were basically using the facts that are on the ground, what was already recorded?
Yes.
Okay.
And one of the things that the report, the audit, was able to tell us is that our whole justice sector, and especially the criminal justice sector, is skewed against the poor. For instance, if you look at our police and policing in Kenya, it indicated that we arrest more of petty offenders and less of violent offenders. And the statistics were 68% of those arrested during the time, the 2 years that we did the study, were petty offenders. Again, when it comes to translation of those particular offenders, we find that when it comes to preferring charges to court, again, very few violent offenders see themselves going to court. We had only 30% in the records that were registered to have been people who were preferred charges for in terms of going for violent offenders. Secondly, there was the question of the duration that you stay in police custody. Of course, the Constitution is very clear about the 24-hour rule, but the statistics that we got indicated otherwise, that in a few instances, in a few police stations, not all, there were instances where people were held more than 24 hours.
And maybe just to be clear, for the sake of anybody who might not understand about the 24-hour rule, maybe just make it clear, what does it state?
The 24-hour rule requires that you're supposed to, after arrest, within 24 working hours, you're supposed to be brought before court. And if the police wish to stay with you or put you in custody longer than that, then they need to seek leave of the court to continue doing so.
Okay, allow me to pause you then. Let me bring in Jasper Ombati, first of all, to hear your comments on what he has had to say so far, especially in regards to the fact that there seems to be more petty offenders arrested than violent offenders.
Thank you, Mr. Gitonga. And I want to start by saying that what he has said could be a fact, that we have more petty offenders as opposed to serious offenders.
Is it that we have more petty offenders, or do we have more petty offenders arrested as opposed to violent offenders?
We have more petty offenders arrested, and this is due to a simple fact, that in essence, if you look around the world, we have more petty offenses committed, and especially in the African context, say the Kenyan context, we have petty offenses being committed because of want. You see, people want, steal because they want to fulfill a certain basic need. You see, as compared to serious offenses, in essence, it's a fact that more petty offenses are committed as compared to serious offenses.
So from the police service, your defense to that would be the sheer volume of petty offenders is higher than violent offenders, and that's why there's that reflection. 68% is rather high.
Yeah, it is high, but remember there is also 32% of the serious offenses. And you see, the police operate, take action on reports which are made to the police station. If somebody reports a case, the police have no option. They have to take action. If they see a cognizable offense, which is a petty offense, they take action, and that adds to the numbers. If we come to serious offenses, of course, some may not be reported, and some are reported. What I'm trying to say is that more petty offenses are reported to the police as opposed to serious offenses.
Okay.
Can I give you a simple example? That in certain instances, you might find an organization which has been defrauded, for example, a huge amount of money, but they may opt not to report. You see? Because they want to keep their reputation. So that is a statistics of the police record.
All right. Let me come to you, Jacob, and possibly your comments, your opening comments before we take a break on the findings of the report, based on what we have just been informed.
Thank you, Michael. The report is substantially correct because it was developed and compiled from records which are maintained by the police, by the prisons, and by the courts. As Jasper has just said, it is true that we charge many petty offenders because of the sheer volume of the offenders. And if we had, for example, the reverse, that there was 68% of violent and serious offenders, this country would have gone down the drain, because it is these violent offenders who can bring the country to the brink. And therefore, that is why you have a large number of petty offenders who steal for various, for example, stealing. Many petty offenders actually commit the offense out of ignorance. For example, in the streets, for example, if you are arrested for having thrown litter, these are the petty cases we are talking about, and that is why we have many cases.
That accounts for the numbers.
Yes.
All right, Lady Justice, there also seems to be, from what he has mentioned, more petty offenders, convicted as opposed to violent offenders. Is that also because of volume, or is there a maybe bigger reason that we've not addressed yet?
Okay, thank you very much for the question. But there is one thing that you must take into account, that courts deal with what is brought before them.
Facts.
Yes, with facts. Not only facts, it is that we cannot synthesize what is not before us. And this comes all the way from the police, passes through the DPP's office, and finally to the court before we disseminate them to the prisons. And the work of the court is not to investigate. It is neither to arrest. And therefore, if we are brought today a volume of drunk and disorderly number of people more than those of violent offenders, then that is what we shall deal with in court. Yeah. Secondly, more interesting, you will find that most of those petty offenders plead guilty. And therefore, the magistrate sitting there trying the person will do the needful and the necessary just to convict and sentence. Probably what we have to look at this point is the manner of sentencing.
Okay.
Yeah, because that is flowing back into the prison, congesting the prisons, and therefore the work of this committee is to relook at how we can treat these offenders. Instead of taking them to the prison, we find better ways of non-custodial sentencing.
All right, and we're going to take a short break. When we come back, we'll look at some of those ways, but also would like to reflect and find out where, by the time the offenders get to court, whether you have a feeling of where the flaw is, because like you've rightly put it, you basically deal with facts. It's what is put on the table that you can only deal with. Even if you thought somebody was guilty, you cannot go out of what facts have been placed before you. So we'll be looking at that. And reminder that you are welcome to participate. For now, we take a short break. When we come back, we continue with the State of the Nation.